Your Honor, I'm Mark Williamson. I represent the movement today, Taylor Shea, the father of the child.
Thank you.
I'm Vicky Shea. I'm representing myself.
All right.
I'm McKenna Isbell, and I represent myself.
All right. Would all those who intend to testify, please raise your right hands and remove yourself off of mute. Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, ma'am.
Yes, ma'am.
Thank you. You all may lower your hands. So we are here today on a motion to set aside a void judgment. I do have some exhibits that were pre-admitted, and we're going to go ahead and admit those now. So Miss Vicky Shea's exhibits A and B are admitted, and Mr. Taylor Shea's exhibits fathers F1, 2, 3, and 4 are admitted. All right, so we're going to take some testimony. It looks like an order in the suit affecting the parent-child relationship was entered by the court back on August the 24th of 2021. And there was a motion to set aside the judgment declaring that order void because at the time that the order was signed, the case had already been dismissed. Is that correct?
Well, the challenge today is to the personal jurisdiction over Mr. Shea and what the court just mentioned, which is a technicality, order of pleadings issue. So to be clear, there's the issue of can one amend their pleadings after their case has been dismissed, and would an amended pleading that's not properly before the court support any order? Our position is no. But secondly, the order should be declared void for lack of personal jurisdiction on my client due to lack of service of process, no waiver of citation, no court appearance, general appearance by my client, and the fact that he didn't sign the purported order that was entered back in 2021. So
Okay.
without those, it's our position that without jurisdiction, the court could not have entered that order.
Okay. Thank you, counsel. Let's see. Ms. Shea, did you want to go ahead and, because all you all are doing, you're giving argument of why.
Buckle up, guys. Today we're going to break down a courtroom moment where paperwork decides more than people. Right from the opening, the case is framed as something far bigger than a family dispute. It's about whether a court order even legally exists. The attorney doesn't argue feelings. He goes straight for jurisdiction, service, and signatures, the three pillars of court authority. If any one of those fails, the entire order collapses. This intro quietly tells you everything you need to know. This isn't about who is right. It's about whether the law ever had power here to begin with.
Why the court should maintain this order.
It should stay maintained. He lived in my house in August 2021 because we are taking him back and forth to work.
Your Honor, for the record, I need to object. Can I share my screen?
Yes, go ahead.
Your Honor, and while I'm doing that, I'd ask the court to take judicial notice of the contents of the file in this case.
Yes, the court takes judicial notice of all contents of the court's file. Counsel, what is your legal objection?
Goes beyond the scope of her pleadings. She filed a response to the petition on September the 2nd, 2025, wherein she said, how can I get this to work? She said, her answer says, I'm stating the lack of sufficient knowledge to admit or deny the allegations. As far as I know, we did not have court on August 19, 2021. So for her to now suggest that she does have personal knowledge, that goes beyond her pleadings. So that's our objection.
Sustain. Okay, Ms. Shea, let me say it to you like this. What Attorney Williamson is saying is that At the time that the court signed this order, the court lacked personal jurisdiction, meaning there was some sort of violation to his client's due process rights because he was not served with a copy of your petition or put on notice about coming to court or anything like that. So that's what you would have to defend of why the court should maintain the order. And the order that you have was signed after this court back in 2019 signed an order dismissing the case. So your order that you have from August 24, 2021 was signed subsequent to the court dismissing the case. So you would be trying to explain to the court why the court should maintain that particular order. Does that make sense?
Yes.
Okay. So go ahead.
Okay. The Taylor Shay was living in our home in 21 in August because we were taking him back and forth to work. Julie emailed us the paperwork under my email.
Same objection. I'm sorry, Your Honor. This goes beyond the scope of her pleadings. Her admission that she doesn't have personal knowledge sufficient enough to either admit or deny my client's allegations.
Sustain. So I guess the better way to say it, Ms. Shea, is what was going on at the time of the order is not the reason that we're here. We're here specifically on technical issues resulting in an order being signed when the court lacked jurisdiction to sign the order. So let me give you an example. I'm looking at the court's record, okay? This court back August 30th of 2019 signed an order
All right, guys, this is where emotion collides headfirst with procedure, and the court makes something brutally clear. Feelings don't override jurisdiction. Every time she tries to explain what happened at home, the attorney shuts it down, and the judge backs him up, not out of cruelty, but out of law. Then the bomb drops. The case was dismissed years ago. That single fact rewrites everything. A judge without jurisdiction is like a referee without a game, powerless. This part shows the legal system's cold truth. Good intentions don't revive dead cases, and courts can't rule on ghosts.
This was all new to us.
Okay.
As of now.
Let me just walk you through it. She dismissed the case back then, okay?
Yes.
2 years after the case was dismissed, you filed an amended petition, and then you also filed a proposed order on the suit affecting the parent-child relationship. You remember doing that?
Yes.
After you filed that proposed order, the judge back then signed your proposed order after the case had already been dismissed. So at the time that the order that you filed was presented to the court, there was no live case pending at the time. You still follow me?
Yeah, but I didn't know that case got dismissed until here recently when I got these papers. When I went down to get these papers, I did not know it was dismissed. None of us knew it was dismissed. I was getting papers for school.
Okay, understood.
Because none of us knew it was dismissed.
Okay.
And then when I got these papers, he was living in the house. He signed the paper because I had the email. He read the papers.
I'm going to object to any testimony that goes beyond the scope of her pleadings.
Sustain. So again, the court just needs to know, even if you didn't have knowledge, ma'am.
Yes.
Legally, there are certain things I'm unable to do just because the law doesn't allow me to do it because I don't have what's called jurisdiction to do so. I have to have jurisdiction to do so. So essentially, what I would need to know from you, not based on what you didn't necessarily know, do you have any case law or anything to present to me today that would allow me to keep this order in place that was signed after the case had already been dismissed?
Like, what do you mean?
Do you have anything where,
Criminal?
no, so
No.
do you have something from a different court, like a court of appeals or something, where another case happened similar to this, and the higher told
No.
that they can maintain this particular order after it was signed once a case was dismissed? Do you have anything like that?
No, ma'am. Because, like I said, we didn't know it was dismissed until I got these court papers. When I
Okay.
got served.
Okay.
Okay, now, this is the moment the entire case implodes on record. Evidence comes out, signatures are compared, and the father flatly denies ever signing the order. And worse, denies ever being served. That's not a small technical mistake. That's a constitutional failure. You can't bind someone to a judgment they were never summoned to defend. Objections fly, but law beats emotion again. When service fails and signatures don't match, authority evaporates. That's how a court order goes from enforceable to worthless in minutes. If this breakdown helped you understand how courts really work, make sure you like the video, subscribe to the channel, and we'll see you in the next one.